Occupational health and safety plays a critical role in workplace investigations. In fact, many investigations are not simply a matter of good management practice, they are legal requirements. In many workplace situations, an employer can decide whether a formal investigation is necessary. However, when health and safety concerns are involved, that discretion often disappears. OH and S laws impose a legal duty to investigate certain incidents and hazards, making investigations mandatory rather than optional. At the heart of most health and safety legislation is a principle known as the General Duty Clause, which we will discuss in depth later. As soon as an employer becomes aware of a workplace hazard that could put employees at risk, there is an obligation to take action. In many cases, that action includes conducting an investigation to determine what happened, why it happened, and how similar incidents can be prevented in the future. Certain events automatically trigger a workplace investigation under OH and S law. The most obvious example is a serious injury or workplace fatality. Whenever an employee suffers a severe injury or loses their life as a result of a workplace incident, employers are generally required to conduct a formal investigation and notify the appropriate regulatory authority. A professional occupational health and safety investigator is also required when there are significant near misses, sometimes called close calls. These are incidents where nobody was injured, but the potential for serious harm existed. Other mandatory triggers include major equipment failures, structural collapses, fires, explosions, hazardous substance releases, and workplace injuries that require medical treatment beyond basic first aid. In recent years, health and safety laws have expanded beyond physical injuries to include psychological safety. Many jurisdictions now recognize workplace violence, harassment, bullying, and other forms of psychological harm as occupational health and safety issues. As a result, employers may have a legal obligation to investigate allegations of workplace violence or harassment under health and safety legislation. Importantly, the duty to investigate does not depend on receiving a formal written complaint. The obligation is often triggered as soon as the employer becomes reasonably aware of a problem. That awareness might come from a verbal report, an anonymous complaint, a witness observation, or something a supervisor notices directly. In other words, if management knows or reasonably should know that a safety issue exists, the organization is expected to act. Health and safety legislation also imposes specific timelines and reporting requirements. In some jurisdictions, employers must conduct an initial investigation within a very short period, sometimes as little as 48 hours, to identify and correct any immediate hazards. This helps ensure that work can continue safely while a more detailed investigation is underway. A more comprehensive investigation is often required afterward. This deeper review focuses on identifying root causes, examining contributing factors, and determining what corrective actions are necessary to prevent a recurrence. Employers may also be required to document their findings, report results to regulatory agencies, and share recommendations with joint health and safety committees or worker representatives. The ultimate goal is not simply to assign blame. The goal is to understand why the incident occurred and what can be done to prevent it from happening again. Failing to investigate when required can have serious consequences. Regulatory authorities may issue compliance orders, administrative penalties, or substantial fines. Organizations may also face increased legal exposure if an injured worker files a lawsuit or regulatory complaint. There are also situations where employers may face claims of negligent supervision. For example, if management was aware that an employee posed a risk of violence but failed to investigate complaints or warning signs, the organization could be held responsible if someone is later harmed. Perhaps most importantly, a prompt, thorough, and well-documented investigation can provide a powerful legal defense. It demonstrates that the employer took reasonable steps to identify hazards, protect workers, and comply with their legal obligations. For workplace investigators, understanding OH and S law is essential. It helps identify when an investigation is legally required, ensures compliance with reporting obligations, and supports the ultimate goal of every health and safety program: preventing injuries, protecting workers, and creating a safe and healthy workplace for everyone.